In this seminar, we'll discuss modern awards and enterprise agreements, which are instruments that contain supplementary entitlements to the Fair Work Act and the NES. These involve more specific entitlements such as overtime rates of pay, penalty rates, systems of work and allowances. Importantly, we'll discuss what these documents are and what they aren't, and how to understand them, how to comply with them, and how to advise clients to get the most out of our services under them. Modern awards are industry-specific documents that sit below the NES. Most people view modern awards as a contract of employment. The fact is, this is not so, or at least it doesn't have to be. A modern award is in fact at its most basic, a safety net. This means that whilst an employee cannot be paid less than the provisions under the relevant award, they can be paid more. Depending on the contracts you have entered into with your temps, you may be able to offset certain provisions under a modern award against other benefits that provide over-award benefits. You should consult me should you want more information regarding this. The most important provision within a modern award is without doubt the coverage provision. This clause will advise whether an award will apply to a type of employer. In this regard, it is important to note that modern awards are in fact applicable to employers and not employees. This means that modern awards are not, as a rule, tied to a specific job, but rather to the industry that the employer is engaged in. There are, however, notable exceptions to this rule. For example, the Clerk's Private Sector Award, which would apply to all clerical employees engaged by employers in the private sector industry. Also important, particularly for Randstad, is that most coverage clauses in awards also apply to on-hire employees in that industry. This means that, regardless of the job that the temp is performing, Randstad must look at the industry that the client is involved in when assessing award coverage. Once you have established that a modern award applies to an employer, you need to see if it applies to an employee. This is done primarily through the classifications, which are essentially job duties. In most awards, the classifications form Schedule 2 towards the back of the modern award. In the event that an award applies to an employer, but the duties performed by the employee do not appear in the classifications, then it is likely that the employee is award-free. A good example of this might be where a transport company employs an office cleaner. The minimum wages section will provide you with an understanding of what an employee's minimum wages for the relevant ordinary work week will be. These amounts are likely to be expressed as a weekly figure only. However, some awards do have hourly rates. It is important to note that these amounts are unlikely to include the casual loading or allowances, and as a result, this is not the minimum amount applicable to a particular worker, even if they work within ordinary hours only. There are generally three types of employment, being full-time, part-time, and casual. However, in some awards, there are further classifications such as fixed-term workers, daily hire workers, and weekly hire workers. Most of the temps engaged by Randstad are going to be casual employees. However, we do also engage some fixed-term contractors in accordance with certain agreements with our clients. The types of employment clauses will generally provide the minimum engagement provisions for each type of employment. Critically for Randstad, the types of employment provisions will include particulars of the relevant casual loading for casual employees and what that loading is to cover. One important thing to be aware of is the existence of the all-purpose loading, which is ostensibly a compounding casual loading, as opposed to the ordinary loading, which does not compound. The ordinary hours are the hours that can be worked by an employee without incurring an overtime or penalty rate. In most awards, the ordinary hours are 38 per week and do not include weekends, although some awards allow for ordinary hours to be worked on a Saturday. However, in addition to the weekly ordinary hours, many awards provide for daily ordinary hours, and some even provide for the manner in which a shift can be worked. Other things to look out for include provisions for rostered days off or RDOs, which appear in many trades-based awards. The shift work clause allows employers to organise or roster work outside of ordinary hours at lower rates than those provided for by overtime. In many awards, there is an afternoon shift, a night shift, and a continuous night shift allowance. If you are engaging temps outside of the ordinary hours, you should familiarise yourself with the relevant shift work provisions of the applicable award. Where an employee works outside the ordinary hours of work and doesn't qualify for shift work provisions, they will be entitled to penalty rates. These can be on overtime hours or on weekends or public holidays. Whilst these rates are often described as time and a half or double time, more often than not, these rates are not adduced simply by taking the rate that you are paying a person and adding a further 50 or 100%. This is because, unless the casual loading is incorporated into an all-purpose rate, then the penalty rate is actually calculated on the ordinary base rate. Allowances are further amounts designed to compensate employees in respect of the costs they incur or conditions that they may have to endure as a result of the nature of work they carry out. Allowances are actually some of the hardest amounts to adjust for when you are quoting to place a temp, and for this reason, it is vital that when you do so, you are aware of the allowances that might exist under your relevant award and, more importantly, the type of work that you are expecting the worker to do. Remember, if you don't cater for it in the contract, the amounts are coming off your margin. Under modern awards, there are usually provisions for both paid and unpaid breaks. Most awards allow for one unpaid break of not less than 30 minutes per shift, exceeding 4 hours. This break must usually be taken within 5 to 6 hours of having started the shift. In addition thereto, employees working overtime will be entitled to further breaks at the commencement of the overtime. Only these breaks are to be paid. You should consult the relevant award regarding breaks as clauses do differ. It is, however, critically important that you understand that breaks are to be taken at the time that is designated within the award. This is because significant penalty rates are often payable to workers who work through their periods of break. Each award differs based on the industry that it is designed to cover. This is why it's very important that you, as the mediator between the client and candidate, understand with some level of certainty the particular award that applies to the situation you are managing. If you are unsure, don't hesitate to contact me for clarification. All modern awards can be located at the Fair Work Commission website, www.fwc.gov.au. Simply click on the Awards and Agreements heading at the top of the page, then click on Awards, then click Find an Award. From there, you will find a list of modern awards in alphabetical order. In the event that a modern award does not adequately suit the arrangements of a particular workplace, the employer and the workers may implement an enterprise agreement to replace the modern award. Like a modern award, an enterprise agreement should not be viewed as a contract of employment, but rather as a safety net. It is important to note that an employee may only be covered by an agreement or an award, but not both, although some EAs incorporate the terms of the award into it. An employee may only be covered by one agreement at any one time. Most importantly, an enterprise agreement is only applicable to the parties to the agreement. That means that unless Randstad is an actual party to an enterprise agreement, it should not be referred to in any Randstad documents with the candidate under any circumstances. Where placing a temp involves paying to parity with a client's enterprise agreement, it is advised that you lift the rates from that agreement and quote them in the assignment sheet with an appropriate set-off clause forming part of the contract. Do not, repeat, do not refer to the client's enterprise agreement. Whilst enterprise agreement terms within the Fair Work Act are deliberately broad as to their creation, so as to allow the parties to devise the best possible agreement that works for them, there are a number of terms or clauses that are mandatory. These include model dispute resolution, consultation and flexibility terms. The agreement must also explicitly identify the workers who are to be covered by the agreement. Most importantly, the agreement must nominate a commencement date and a nominal expiry date. The nominal expiry date must be no longer than 4 years from the commencement of the agreement. The nominal expiry date governs when an agreement may be renegotiated. However, it does not terminate the agreement. The agreement carries on until it is replaced or it is terminated by the Fair Work Commission. There are also a number of illegal terms that cannot be enforced in an enterprise agreement. These include discriminatory terms, opt-out terms, objectionable terms, and terms that are inconsistent with the NES. In order to commence bargaining for an enterprise agreement, notice must be given to every employee via a prescribed form, known as a Notice of Representational Rights. This document cannot be altered in any way other than as prescribed and is designed to advise employees of their rights to appoint a bargaining representative for the purposes of negotiating the agreement with the employer. Any person can be a bargaining representative, other than a union official whose union does not cover the type of work that is being performed in the workplace. Once the representatives have been appointed, bargaining for the agreement may take place. This involves the parties meeting to discuss the potential terms of the agreement. These meetings must be held in accordance with the good faith principles of the Fair Work Act, which state that parties must consider and respond to the proposals of each of the parties. There is no obligation, however, to agree or concede to any proposals of any other party. Once bargaining has occurred, and the employer has a document that it is happy with, it may schedule a vote on that agreement, where all employees who are to be covered by the agreement may vote on it. However, it is not compulsory to do so. There is no any one accepted method of voting. A successful vote will consist of the majority of votes being in favour of the agreement. The vote must be as transparent as possible, and there cannot be any suggestion of pressure on the part of the employer. Once a successful vote has occurred, an employer must lodge an application together with the agreement in order to have it registered by the Fair Work Commission. The application must be lodged within 2 weeks of the vote having taken place, and will include a statutory declaration to be signed by the authorised person. This statutory declaration includes details of the bargaining, the vote, and the agreement. Critically, it requires an analysis as compared against the relevant modern award for the purposes of assessing whether the agreement satisfies the Better Off Overall test. This information will then be scrutinised by a Commissioner of the Fair Work Commission, who will decide whether to approve or reject the agreement. An enterprise agreement may only be approved if it is considered to be better off overall for all employees covered by it than the modern award that it is replacing. What exactly is meant by better off overall is not defined by the Fair Work Act, and this has led to considerable inconsistency of commissioners' decisions in assessing agreements. Some commissioners apply a factual interpretation, seeking the employees' rosters in the past to determine whether or not they will be better off. Other commissioners apply a potential interpretation, requiring undertakings from the employer that they will not seek to invoke conditions via the enterprise agreement that will see a worker worse off. All registered enterprise agreements are a matter of public record and are available for download and view at the Fair Work Commission website www.fwc.gov.au. You can, however, always contact me if you are having trouble locating an agreement. The benefits of an enterprise agreement are generally a matter dependent on the relevant circumstances. Some EAs actually remove a lot of fiddling about in terms of allowances and so forth by incorporating it into rates, thus making things easier for payroll function. However, the major benefit for employers is that once an enterprise agreement has been registered, it sets the terms and conditions of employment for the duration of the agreement. Employees and unions cannot strike once an EA is in force. Of course, the privilege of this certainty comes at a cost, usually being higher minimum wages and conditions, and this needs to be considered carefully. Coming up in our next and final seminar, we'll talk about the specific situation of IR as it pertains to labour hire and Randstad. We will discuss the transition of temps from clients and competitors alike, as well as looking at the various types of employment contracts and arrangements that might be used to deliver the best possible service to our clients and candidates alike.